So, as Josh mentioned, we'll talk about SEP licensing practices and what's taking place in Europe, first and foremost, but we will then segue into what is happening in the United States and what the US can learn from the good and the bad in Europe. So I have a very distinguished panel here with me. What I'm going to do is I'm going to introduce each one as they begin to speak, so we don't spend a lot of time at the beginning, and then you'll forget by the time we get to them. So I'll introduce each one in turn. The way we'll do this, everybody will speak on their own for a few minutes, and then we will engage in a conversation, and towards the end, we'll want to hear from you and get your questions. So please let us know. Start preparing your questions and definitely speak up at the right time. I want to make sure that on behalf of everybody, people are here on their own behalf, and whatever the panelists say is their own views, not necessarily the views of their companies or law firms. For me personally, it's got to be clear that whatever views my partners take in their pleadings in front of courts are the correct views. And not what I say here. So with that, let's begin, and we'll begin with Justus Baron. Justus is a senior research associate at the Center of Law, Business and Economics at Northwestern University, Pritzker School of Law. He specializes on empirical economic analysis of technological innovation and markets for technology. He's particularly focused on standards and standard essential patents. He publishes a lot in that area. He was also a member of the European Commission's SEP expert group, but no blame is to be assigned to him for whatever comes out of that commission. Justus is an economist. As you can probably imagine, he's got a PhD in economics. With that, Justus, please.
Yeah, thank you very much, Andrei. Thank you very much to the organizers for having me here and putting me in this comfortable position of being an economist commenting on case law in Germany. So, given my field of expertise, and given the fact that we have Claudia on this panel who will also talk about German case law, I'm gonna keep it light on individual cases, and I thought that what I can offer is a little bit of a takeaway from data analysis that I've started doing about German case law, where I try to analyze and code a little bit the decisions at first instance decisions, which I believe is relevant, because we hear a lot about companies' concerns with Germany, and other companies obviously believe that German jurisdictions is important for them to help them enforce their rights. So given that internationally there's quite some focus on German courts, I believe it's important to get a little bit of a better empirical understanding of how these cases are actually turning out, especially at the first instance level. Just very briefly as an overview, I think it's fair to characterize the German case law in recent years in different phases. So starting with the Federal Courts of Justice's decision in the Orange Book standard case, which, as most people would probably agree, sets a fairly patent holder-friendly standard in which an implementer can only escape an injunction once being found to infringe a valid standard essential patent if he has made an offer to license these patents on terms that are such that the patent holder could not refuse these terms without abusing its dominant position. So it's up to the implementer to come up with an offer, and that offer has to be such that any offer that is, any rejection of that offer would be unreasonable. And that standard has been broadly replaced, I would say, when the European Court of Justice came in the Huawei ZTE decision. I believe John is going to talk a little bit more about that, and also Claudia about the framework that this establishes. But it's also fairly well known. So the European Court of Justice puts the onus on the patent holder to first notify the implementer of infringement, and then the implementer has to state its willingness to take a license on fair, reasonable, and non-discriminatory terms, upon which it is then the patent holder or the licensor that has to make a specific and written offer for a license on FRAND terms, upon which the alleged infringer has to diligently respond to the offer and submit, in case of disagreement, submit a specific counteroffer on FRAND terms, and also provide appropriate security in accordance with recognized commercial practices. So this is broadly the framework that the Huawei ZTE decision has created. But then in the German case law, which is by far, with over 90% of the decisions in the EU that are rendered according to this framework, more than 90% of the decisions are made in Germany. So it's by far the jurisdiction that concentrates the actual implementation of this framework. There have been, I would say, two different approaches which concentrate on the, I wouldn't say the order in which these different steps are assessed, as would say, but it's in the relative emphasis at which these different steps are assessed. So some decisions would emphasize the scrutiny of whether the licensing offer by the SEP holder was really made on FRAND terms, and basically rushed through, I would say, or like it's just tick boxes more easily on the previous steps, in particular the step of the expression of willingness. So this is basically as long as the implementer has stated that he is willing to license on FRAND terms, then he has fulfilled that requirement, and then we can immediately proceed to examining the FRAND offer. Whereas other decisions have said, okay, this statement in itself is not what is required, but the statement has to be substantiated with actual conduct that reflects this willingness, and therefore there's more emphasis on looking at how parties have behaved after making the statement. So these two different approaches, I would say, have been settled, or there has been like a federal court of justice decision in Sullivan versus Higher, which kind of establishes the German case law, how German courts have to approach that. And it is closer on the procedural side, but I don't want to get into the analysis of individual decisions because I think Claudia will do a much better job at that than me. So based on that, I'm going to just give you like a little bit of an overview of the data that we have collected, or I have collected, of decisions that follow this basic framework. So all these are decisions that were published after the original Huawei ZTE decision, and only cases in which the plaintiff actually requested injunctive relief, excluding cases where it's about injunction against a party seeking injunction in a foreign jurisdiction, so it's not including anti-suit injunctions here. And it's only cases in which the defendant raised a FRAND defense, and it's only cases in which the patent was found infringed and not found invalid by the Federal Patent Court prior to a decision on infringement and remedy. So these are cases that were decided based on the merit of the FRAND defense that was raised by the defendant. And I only look at decisions of the first instance, which in Germany is a Landgericht on these issues. And so here's the sample. It's a sample of 49 decisions. And it includes what I would call the pre-Huawei cases, even though these cases even though there's 2014 in there, which I don't really understand, but I mean, they are decisions that are published after the Huawei ZTE decision, but they were initiated prior to the Huawei ZTE decision. So they are what in Germany was called transition cases, where the judges said it's possible for the parties to do some of the things that the Huawei ZTE framework requires of them after initiating the lawsuit, just because they didn't have the benefit of that decision before initiating the lawsuit. And the outcomes of these decisions are actually quite, I would say, balanced in the sense that it's not true that, as is often portrayed, that German courts automatically and always grant an injunction if the patent is found infringed and valid. So especially excluding these transition cases, it looks more closely like an even split between cases in which the friend defense was successful and cases in which the plaintiff prevailed and got the injunction that he requested. And looking at the different courts, so there are 3 courts in Germany that have taken on these cases, and the 2 courts that have taken on the vast majority of these cases, so 17 cases in Düsseldorf and 18 cases in Mannheim, they are almost perfectly split between granting injunction and not granting the injunction. The exception here, at least in my data set, is Munich, where I don't find a successful friend defense in my data set. And one of the potential explanations for that is that the cases that were brought to these different courts are different. And Munich got a lot of the cases in the automotive industry, and maybe the existence of a pool in that was a licensing offer had made it easier for the courts to find that a friend offer existed, or I don't know. But I mean, there is, in any case, there has been a more favorable outcome for the patent holders in these cases than for friend cases in Germany in general. One of the things that we can look at in German cases is to try to get a measure of the magnitude of the dispute. So the German courts, for the purpose of determining fee shifting, how much the prevailing party can ask to be reimbursed by the other party, the court determines what is the amount in dispute. So we can look at the distribution of the amounts in dispute and compare that with how patent litigation in general are distributed. So we see that these cases are somewhat skewed to more valuable amounts in dispute, but not that much. I mean, they're not that different in terms of the distribution from your regular patent litigation case. The only difference is that you don't get these small value disputes below 500,000 euros that make up 30% of patent litigation cases, otherwise, for other patent cases. But now looking at how these outcomes differ between larger and smaller disputes, we actually see that the smaller cases are perfectly balanced between granted and not granted. And then for the bigger cases, I mean, there's just one very big case in which case the injunction was granted. But otherwise, like the split seems to be fairly even between grant of injunction or not grant of injunction, independently of the size. I have to say that I can only do this for the decisions of the court in Düsseldorf, which is the only one that very transparently puts the amount in dispute in the publicly available decision. Another thing that is interesting to look at, Fabian already alluded to that yesterday, is the speed at which these cases are resolved. So Germany excels in that dimension, comparing German courts to any other jurisdiction. German courts appear to be particularly fast in rendering a decision in SEP litigation disputes, with decision in, on average, 14 months after complaint, which is more than 2 times faster, for example, than France or UK. And another thing that is talking about the timing that is interesting is to look at not only the delay between the date at which the complaint was filed and the decision was rendered, but also taking into account the pre-litigation conduct, which is, because of this Huawei ZTE framework, always described in fair detail in the decision. And then you can see that on average, it takes about 5 years, I would say, from date of first conduct to judgment. But there's obviously a huge variation in that. So in some cases, it's it's not that unusual. In 10% of the cases, it takes more than 10 years from first contact to the date at which the court actually makes a decision. And here, that's where I think probably the most interesting piece of data comes in. We can see that this difference really matters in terms of the outcome. So we see that looking at the cases in which the injunction was granted, the time that had elapsed from the first contact between the parties to the date at which the complaint was filed is twice as long as in the cases in which injunction was not granted. And we can look at the distribution, and we see that the vast majority of cases in which the plaintiff had initiated a dispute within less than 2 years after first contact do not result in the grant of injunction. Whereas in cases where there had been more than 5 years before the plaintiff initiates the dispute, there are 4 cases like that, and they have all resulted in an injunction being granted. So this is really, I think, a data point that points to this procedural approach that the courts have adopted. You could interpret this as saying that a patent holder that has really exhausted his options, they have really diligently tried with all different kinds of things to come to an agreement before initiating the dispute, they tend to fare better at the court. Or you could interpret this as to say that cases in which implementers or alleged infringers have been dragging their feet and therefore it has taken so much longer, they tend to fare not that good and have a higher risk of facing an injunction at German courts. So just to take away, German courts are fast and they are very, very cheap compared to US or UK courts. So it offers affordable and expedient resolution. But the outcomes actually vary. It's not true that courts systematically grant injunctions without consideration of the merit. It's true that no German court, to my knowledge, has ever determined a friend rate. But the friend character of the offers is often, even though not always, considered by the courts. And then if we can try to assess what are they doing right, then instead of saying, okay, what can we learn from it in terms of imitating it or emulating it, I think it's more like, what does this case law contribute to the overall global picture? I would say that German case law contributes to increasing clarity, in particular on the procedural requirements. So some of it is very, very formal. You know, like it's what is the amount of time that you have to answer to the notice of infringement? At what degree of specificity do you have to identify a specific patent as being infringed so that it's considered a valid notice of infringement? So to some extent, this is just what German courts offer to the picture. They offer to the picture that if a party is falling short on these very procedural requirements, then it will lose on the merits in German court. So you could say it's not out of character for the Germans to take on the role as being the ones to hold people to formal correctness. But then obviously they don't, or so far they have not attracted parties that were looking for a friend determination, especially in a complex dispute. And maybe, I mean, Claudia might have different views on that, but maybe also the system is not the perfect choice if that's what you're looking for. So the question whether third-party determination would be considered as an indication of willingness is also something that Claudia might want to say something about this. But I think that German courts would, in general, look at something like if one party were to look for a third-party determination, which could be arbitration, it could be a foreign court, I think that would be regarded favorably in terms of, okay, it's a party that actually tries to resolve this dispute. And it might even be required under the new proposed EU regulation that Andrei has alluded to, and which obviously might completely change the picture that I've just tried to present. But that's basically the takeaway that I have, and with this, I exceeded my time.
Thanks, Justus. You've done a good job selling the German courts. They'll be proud of you, I think. Can I ask a question or two? Have you done any study comparing the rate of injunctions for SEPs in Germany versus other European jurisdictions like France, UK, on the injunction question?
Yeah, so we did a comprehensive empirical analysis of EU court decisions. As I said, in general, German courts get more than 90% of these cases. And to my knowledge, all the cases in France were resolved on other matters before it came to a friend determination. So I don't think that there's enough data to really base a comparison on, just because of the small number of cases that there are in some of these others. I think the closest in terms of numbers of decisions that probably could be used for comparison would be the Netherlands. But even that is a smaller number of decisions, and I haven't coded that in a way to try to compare.
Okay, great. Thank you very much, and we'll continue the conversation. We'll turn it over to John now.
Sure.
Yep.
Thanks.
Thank you very much. Now, John Kolakowski, he is the Director of Patent Licensing and Head of IP Regulatory Affairs for North America at Nokia Technologies. He's negotiated lots of patent and technology licenses for Nokia. He also represents Nokia before government regulatory authorities, such as at the USPTO. And elsewhere, and at standard development organizations and other trade organizations. He is a lawyer. He has a JD from Northwestern University, and he has a degree in chemical engineering before all of that. So there will be a trend, as we will see. John?
Yeah, thank you, Andrei. I'm going to shift now to talk some about the most recent FRAND decisions in the UK and the significant decisions that have come out of that jurisdiction. And then I will pass it over to Claudia, and she will then talk specifically about the German decisions that are relevant to FRAND disputes. I'm going to keep myself on schedule, too, with a timer up here. First, before I start talking about the UK decisions, I just want to give you maybe a little bit of background on UK patent litigation, because it might be helpful, because there are some notable differences between the US and the UK systems. The UK courts are divided into 3 jurisdictions, but most patent litigation is in the courts of England and Wales before its patent courts. There are no juries, which is obviously the biggest difference between the US and UK. And you also have specialist judges that usually have technical backgrounds or training. So you can feel pretty confident that there's going to be a pretty good comprehension of the law and the facts by the decision maker if you're in there for a patent-related case. With respect for damages for infringement, the general principle is that the patent owner has to be put in the same position as if the infringement had not occurred. And the patent owner must therefore be compensated for all reasonable foreseeable losses that are suffered as a result of the infringement. There's no punitive damages, but there is a loser pays system so that the loser does pay the winner's reasonable legal costs, which is typically 65 to 80% of the total costs, as I understand. And most notably, the successful claimant usually gets a permanent injunction, in contrast to the state of the law in the United States. Usually there's split trials so that liability is determined first, and then if necessary, damages will come afterwards. And then maybe the last thing to note about the UK is that it's a common law system. So the UK courts are bound by the prior decisions of the higher courts in the country, and at least prior to Brexit in 2020, they would have been also bound by the European Court of Justice determinations, such as the Huawei versus CTE decision that Justus alluded to. I was going to speak a little bit more about that Huawei versus CTE decision, but Justus covered it pretty well, so I think in the interest of time, I'll skip right over that. But just note that, or remember that it had the various different steps in what you call the FRAND dance, where the licensor and the licensee each have obligations that they are supposed to fulfill in order to show that they are meeting their FRAND requirements, both as a willing licensor and a willing licensee. Turning now to the UK cases, the first and most significant of these is the Unwired Planet versus Huawei decision from the UK Supreme Court in August of 2020. So it's a pretty recent vintage. The court held there that when a standards implementer infringes a valid UK SEP, the appropriate relief is what we call a FRAND injunction. This restrains infringement until the implementer enters into a license held by the court to be FRAND. So basically, you're going to be enjoined unless you agree that you're going to take the terms that the court sets in the decision. In addition, and most notably, and this is the one that generates a lot of controversy, the Supreme Court said in this decision that the FRAND license could be a global license if it was appropriate. So an implementer could, in certain situations, be forced to pay for its infringement all over the world, or be enjoined from selling its infringing products in the UK. The court provided examples of when this might be appropriate. They said if the SEP holder's portfolio was large and global in nature, if the defendant operated around the world selling its products all over, or if it was customary in the relevant industry to enter into worldwide licenses. And that is a feature of the wireless communications industry that happens to engender a lot of these FRAND decisions. The global license idea is to say, at the very least, controversial. Implementers argue that the court in such instances is improperly exercising extrajudicial jurisdiction over sales in other countries that should be the domain of other courts in those respective countries. But the court, in this case, noted that an implementer could always challenge the essentiality or validity of foreign patents in those jurisdictions and then seek a reduction in royalties if important patents were found to be invalid or infringed in other jurisdictions. But I guess if I were an implementer, I would say that's easier said than done. And that would be the big challenge and controversy. Another significant conclusion of the unwired plant decision is that a range of FRAND royalty rates is not hard-edged, or at least not at the bottom. So not all similarly situated licensees have to get the same rate. And a licensor could choose, permissibly, to offer sub-FRAND rates to one party as long as it's not requiring super-FRAND rates of another party that's similarly situated, and therefore not distorting competition between similarly situated licensees. In the case at bar, in the Unwired Planet decision, another licensee, Samsung, had gotten what you would call a sweet deal because it had settled before trial when the patent holder, Unwired Planet, was cash-strapped. So Unwired Planet was willing to do a sweetheart deal with Samsung in order to get the money that it needed to continue its litigations, at least in part, against other defendants. Huawei wanted the same rate, but the court said that wasn't required under FRAND, as long as Huawei was being offered a FRAND rate. And last, I'll note that this case interprets the Huawei versus ZTE to set standards of behavior against which parties' behavior can be compared to decide if there's been a competition law breach. The court said that Huawei versus ZTE standards provide a safe harbor, but the failure to follow those procedures doesn't necessarily mean that the conduct doesn't satisfy FRAND. So it's an important distinction, I think, to remember. Chronologically, the next important decision we see comes 2 years later in an appeal of a Nokia versus Oppo decision. Let me just note for the record here that I don't have any involvement internally with those decisions, so anything I'm saying about them is public information and no insider's knowledge as far as that goes. The first Nokia versus Opto case was notable really because it said that with the possibility of a global FRAND license remedy that Unwired Planet had set forth, that English courts can go ahead with such determinations even if another court, in this instance China, had already agreed that it was going to go forward with a global FRAND rate determination. So just because a foreign court had already decided it was going to do something didn't mean that the English courts couldn't go ahead and also do the exact same thing. So it sets up the possibility of inconsistent judgments and perhaps a race to the courthouse, or at least a race to the jurisdiction where you think you'll get the speediest resolution that might be enforceable. Next, we have another decision a couple months later in 2022 in the Optus versus Apple matter. This one's notable for really just one reason, and that was that the court said an adjudged infringer could be required to agree to a court-determined license to avoid an injunction, even if the court had not yet set the terms of that license. So Apple was told, you're infringing, you need to agree that you're going to sign up to a license, even though we can't tell you right now what those terms are, or you're going to be enjoined. This greatly upset Apple. They threatened to leave the UK market over the decision, but they eventually backed down and agreed. But the UK Supreme Court recently agreed to hear an appeal of this decision, so we haven't heard the final word on this one yet. So to this point, the UK decisions I've described to you seem like they're very patent holder friendly. But And to this point, the UK was gaining notoriety, and many large patent holders engaged in worldwide disputes were racing to file cases there, thinking that this is going to be the best jurisdiction for them, and it would be advantageous to gain leverage over holdout licensees. But then just in April of this year, we finally get a royalty rate determination from the England and Wales High Court in the InterDigital versus Lenovo case. And it incorporates all of those advantages in the law that were favorable to the patent holder, but then it determines a royalty award that was very much more favorable to the implementer, Lenovo. Lenovo had wanted a blended rate of 16 cents per device. InterDigital had argued for just under 50 cents. The judge's determination landed very close to Lenovo's position. He determined that a FRAND royalty rate for InterDigital's portfolio should be 17.5 cents, so just over what Lenovo had wanted. The grand total for damages was just under 140 million, which is still a pretty significant sum, and we'll come back to that in just a minute. The royalty was based on comparable licenses, court rejecting the idea of the top-down analysis from a theoretical aggregate royalty. Lenovo had provided 7 comparables, and InterDigital had provided 20 comparables, but the court found that Lenovo's 7 were much more realistic and comparable to Lenovo, whereas InterDigital's comparables the judge found fault with, in particular because InterDigital had cited a number of cases against smaller licensees who really didn't have the same bargaining power that InterDigital had. The good news on that front for the royalty, for the patent holders, though, was that the judge decided that the royalties should extend all the way back in time to the beginning of a dispute and not just be limited to relevant statute of limitations. The judge concluded that a willing licensee would have been willing to take a license for the entire set of damages if they were truly willing, and wouldn't have just limited itself to what a licensee or what a licensor could recoup in a court decision. I'm running short on time, I see, so let me try to just skip through and see what other important points I want to hit on this. On that case, it's also important to note that the court concluded that an implementer can become willing at any time up to the point where it must cease infringement. So you can do it even, the implementer can even become willing during the court decision itself when the proceedings have already begun. So this seems to kind of make the willingness analysis in Huawei versus ZTE almost meaningless. So it's definitely a point of controversy and one that we'll need some further clarification on in the future. The court also kind of discounted the idea of offering volume discounts, even though that's a common practice in at least wireless licensing. They said that this would discriminate against smaller licensees. So it's questionable now whether reasonable royalty comparable licenses might be comparable if indeed they're given a significant discount for being an early mover or a high volume seller. I'll mention that another decision came out soon thereafter in another one of the Optus v. Apple cases. And again, it was a royalty rate that was awarded that was very much closer to what Apple had wanted, the implementer. Definitely did not give Optus, the patent holder, anywhere near what it was seeking. Here, there was kind of a blending of the comparable license and top-down approach in terms of the court finding what its royalty rate was. And I think it's also notable for the fact that this most recent Optus versus Apple decision, the court limited the past damages to only 6 years, which would have been the longest statute of limitations applicable in the worldwide jurisdiction, which would be the United States. So here, it seems in conflict with the InterDigital case in that the judge here did not take the royalties all the way back to as far as they could have gone to the time of first infringement when the beginning of a negotiation would have taken place. And I will just say the last one to talk about very briefly is that there's another recent UK decision from the Nokia versus Oppo dispute. And there we have Justice Mead from the High Court in July of this year concluding that Nokia is a willing licensor and that Oppo, in contrast, is an unwilling licensor because Oppo is insisting only on terms that might be set in the Chinese FRAND rate setting proceeding that it has already started. The court here said that the patentee can choose between different FRAND terms that are set by different courts. So that's another interesting decision. APO was supposed to decide by September whether to commit to a FRAND injunction or be enjoined, but they would not so commit. An injunction was issued, but it's currently stayed because APO is pending the pending appeal of the willingness decision that the court made. Whew. Okay, sorry. Went a little bit longer than it should have, and now I will shift and transition to Claudia, and she's going to tell you about the German cases.
Thanks, John. I do have, I have a couple of follow-up questions, but let me ask you first, this concept of global royalty rates, and there are all the legal problems that you have mentioned about potential jurisdiction and impinging on other countries' sovereignty and so on. But from a pure business perspective, what is it good or is it bad for patent owners, and is it good or is it bad for implementers, or does it depend on how the royalty is actually set?
Yeah, I think the answer is it depends. As a patent holder, you like the idea at first because it can prevent holdout licensees from simply making you go jurisdiction to jurisdiction to jurisdiction to enforce all of your patents. If you have one court that's going to say, look, you're going to be enjoined in this country if you don't sign up to a worldwide license, well, then that prevents that, or could possibly eliminate that holdout problem if the licensee's market in that particular jurisdiction is so large that it wouldn't want to abandon it. But as a patent holder, you also have to be concerned about just what kind of royalty rate is going to be set. Obviously, you had thought that the UK was going to be a favorable jurisdiction, but now these decisions are coming out and they look to be pretty low royalty. Most people think that when the Chinese courts finally do issue another royalty rate determination, which is actually coming up in the Nokia versus Oppo dispute, most people are projecting that it's probably going to be on the lower end of the royalties based on historical precedent. And then we haven't really had a lot of royalty rate determinations in the United States either. So it's good for preventing holdout, but makes you nervous as a patent holder for maybe be careful what you ask for.
Well, you're putting all your eggs in one basket effectively, and it certainly is an odd outcome, patents being territorial in nature, and portfolios are different in different jurisdictions, even for big portfolios. They're not all the same. And
yeah, I would just say, speaking as a patent holder, I think ideally we would say it should be fine as long as both parties agree. If both parties agree, yeah, let's have the court set a worldwide rate and let's do it, then it should be permissible. But what it really comes down to is this is a very similar idea to what a lot of patent holders prefer, which is simply to go to an arbitration that would decide all of this in one jurisdiction, one court, in front of experienced and probably educated finders of fact.
Okay, great. Well, thank you very much. Let's turn over to Claudia. Claudia Tapia Garcia. She is the Director of IP Policy and Legal Academic Research at Ericsson. She leads the Research IP Policies team at Ericsson. Before then, she was Director of IP Policy at BlackBerry. Claudia has a law degree from the University of Valencia, an LLM specializing in international patent law from the Ludwig Maximilian University in Munich, and a PhD on FRAND issues and standardization in the telecom sector from Augsburg. So lots of other things here. I'll just mention that one of the favorite entries in her resume is that she says she is truly a global citizen. So
that was the communication department responsible of this.
Claudia.
So hello everyone, it's a real pleasure to be here. It's Friday afternoon and you are here. So I truly appreciate that. And let's make it worth it, right? Justus has already mentioned all these steps, so I'm not going to repeat them in what goes from the Court of Justice of the EU the responsibilities of both parties, licensor and licensees. By the way, I have sent already the slides, so you can have them afterwards. You will receive the same thing as you see here on the screen. Let's go with the first step. How do German courts interpret how the offer has to be? So the patent owner, before making the offer, needs to do the notification, right? And here what the courts say is that it has to specify the patents, the relevant standards, as well as indicate the products. And here, the courts made it clear this is not about detailed legal or technical explanations of the use of the patent. They also recognize that claim charts as part of the commercial practice, and this is why they are sufficient to fulfill the notification requirement. They also argue that it is sufficient to notify a parent company because they assume they will notify also the others. What about the implementer's obligation to express, without delay, its willingness to conclude a front agreement? What does it mean, really? How much time are we talking about? Well, the court says the more expertise you have or you have access to, the shorter the time to express your willingness to conclude a license agreement. Makes sense, right? On average, they think it's around 2 months. That's what they expect from our average licensee. But the implementer is expected to seek front license as soon as possible. And this means that they should be motivated to urge the patent owner to engage in licensing negotiation, and if something is missing, connect to them and really engage in these negotiations. This declaration of willingness has to be clearly and unambiguously serious, unconditional, no conditions attached with that willingness, on whatever terms are in fact front. And it has to engage in a target-oriented manner. But now back to the offer. German court says that the offer of the patent owner has to contain all the essential terms of the agreement. And this means that basically once you have the offer as implementer, you can take it and sign the agreement. But the first offer is basically just to have enough information for the potential licensee to consider it, make amendments, and then do, if necessary, a counteroffer. So, as we heard, this is kind of the dance between both of them. So it's generally front compliant with respect to the average licensee. An important point, and unfortunately it didn't come out well in this screen when we moved them, but this obligation is only triggered if the licensee has expressed adequately the willingness. Without this, no obligation to make a front offer. They recognize that worldwide portfolio license is commercial practice unless there are circumstances that justify not to make it, it's considered front. For example, if the implementer is only selling in one market, for those cases, it makes sense to have a front offer for that. But otherwise, worldwide portfolio license is fully okay. Front is a range of acceptable royalties. It's flexible to allow the parties to address the specific circumstances of each of them. And similar situated users must be treated equally, unless there's a justification for this difference. And in any case, we don't consider front as allowing most favorable license. What does it mean is that there's no favorable licensee principle. It means that as a patent owner, you're not obliged to give the same favorable offer to every licensee. Comparable agreements are being seen as an important indicator for front. Top-down approach, the German courts have said there's no legal concern there, but they have applied it very rarely. Cost-based methods, as for example, determining front based on the cost of the development of the product. This is not considerable suitable for front determination. And the court argued this is because it misses very important elements, such as the creative art of the invention. Counteroffer. Let's see if the implementer does not agree with the offer, it's obliged to do a counteroffer as soon as possible, taking into account the recognized commercial practices and the good faith principle. If the implementer is active in several markets and is making a counteroffer only for one market, this would be considered as unwilling. There's something that German courts have taken, by the way, from Orange Book. So Justus explained one of these possibilities that the implementer had, which is to make the counteroffer. And it was indeed very risky in Orange Book, because if they didn't get it right, they will never get a front defense. But the court allowed, as now, that the implementer grants the SEP owner the possibility to determine front, while reserving the right to challenge it afterwards. So for non-very experienced implementers, that could be a possibility. So they kept it from the Orange Book, that part. What do they use as basis for calculation? We've seen in IP Bridge versus DCT that DCT insisted in having as basis the average selling price, the lower average selling price of its own devices. And the court saw that as really not willing and not seriously willing to engage in negotiation, while it accepted the IP Bridge annual worldwide industry-wide ASP. They also considered that volume discounts, here difference from the UK, are acceptable if there's justification. For example, in this case, the court thought, well, here you are encouraging implementers to sell more, which in principle should be sufficient. One element too is important is regarding the counteroffer, asking the patent owner to fundamentally change the licensing model. Let's imagine that I, as a patent owner, license always to end user products, and someone is asking me to go to a different level. Here, the court says you, as a patent owner, should not be required to do that. Reason is that by doing so, your existing licensees might accuse you from discriminating, and you might be forced to then change all the other agreements with this new license structure. And this cannot be expected for a willing licensor. In any case, and this is something that the courts really insist, as an implementer, you are obliged to react and engage in licensing negotiations, even if you find maybe a clause which is obviously not front. This is not about accumulated information for your front defense. It's about really engaging. And when you see something, then speak it up and really engage in the negotiation. There's only one exception, which is when you see that the offer is not seriously meant. In that case, it's fine. Otherwise, please continue engaging. That's very important for Germany. Finally, security. You should render accounts regarding acts of use and provide security for potential royalties, both in accordance with the counteroffer. And this has been done shortly after rejection of the offer. Another point which I will point out, because I think that's something I haven't read much, but I think it's important, is regarding damages. The damages don't start counting from the time that they are sued or notified, but from the time of infringement. That's, I think, also important to consider. And I have put here all the decisions with the paragraphs, so that you can, after that, when you get time, learn more. Wow. And I encourage you all to go through the forapcouncil.com and see all the summaries in English of all these decisions and all the European case law decisions. And that's it from my side. Thank you very much.
Thanks, Claudia. These decisions are in the context of determining, just one question.
Yes.
These decisions are in the context of determining whether you have a willing licensor and licensee, and therefore the court should or should not issue an injunction, or were these relevant also to rate setting?
No, Germany has been focused a lot in the behavior of the parties. This is also because until now, nobody has asked German courts to determine fraud. So they have been looking at what have been the behaviors according to Huawei versus CT. At the very beginning, Germany was more strict. They were looking at step 1, step 2, step 3. And in the meantime, they have adopted more the Netherlands, UK vision, which is really looking at both parties, how they are really behaving. Are they truly engaging, or one is playing games and delaying? And this is something they can see. And what I like is that the German courts also explain those cases. So you get the dates, you see the strategies, and this way you can have a bit of understanding what the licensing negotiation was, if they were ignored, or they, like in one case, for example, they expected 3 years, and after that they say, oh, I want to have the claim charts for every single patent of your portfolio, which we know this is not done usually. So, behavior.
Okay. Thank you very much.
Thanks
Thank you,
to
Claudia.
all of you.
Andre, if I could add just one briefly on that point, we probably would have had a German decision that would have set a FRAND royalty rate in the Nokia versus Oppo dispute, but Oppo's, probably because Oppo's market share is so small in Germany, that they actually chose to just abide by the injunction and left the market.
Yeah. Okay. Well, thank you much. Last but not least, KRAdamo. Ken, you have to bring it home in your allotted time. Sorry about that, but that's what happens if you're the last one on the panel. So Ken spent his career doing lots of jury and non-jury cases in various courts across the United States, at the ITC, at the PTAB, arbitrations, everywhere where disputes existed and were heard. He was at Jones Day and lastly at Kirkland & Ellis. He has more accolades than I can count. Everybody gave me a page of their resume for Ken. I have many, many double-sided pages, just an attestation to his very distinguished career. He began as a chemical engineer and also has law degrees and LLM as well. No, you cannot start the 10 o'clock minute now, the 10-minute now.
I'm not restarting it. I mean, I'm lucky I'm going to get enough time to breathe here. Good afternoon. This is one of the things that when you speak to large groups, you do something that distracts but is interesting. It's the famous story about the very well-known American trial lawyer, Clarence Darrow, who, back when you smoked cigars, Darrow put a woman's hat pin in his cigar. You were allowed to do this in the courtroom. While opposing counsel was summarizing the case, he lit the cigar and he started smoking it. Of course, and he's smoking and smoking, and the ash is getting longer and longer. But because of the pin, the ash didn't fall off. Everybody in the courtroom is watching that cigar, waiting for the ash to fall off. Nobody paid a damn bit of attention to the other side's closing argument, and he won. So you just saw a little bit of an attempt to do that. Look, I have nothing good to tell you. It's very simple. We have been in this country, 2013 to today, we've spent 10 years trying to come up with a U.S. government policy statement that covers SEPs and injunctions. We've been through Obama, we've been through Trump, we've been through Biden. I want you to remember these dates, so we're going to go through this quickly. 2013, 2019, draft 2021, June of 2022, and nothing. Right? Remember the and nothing. We haven't got anything today. Okay? commentators have called this whipsawing to an amazing degree. So basically, the country has been whipsawed by the Department of Justice Antitrust Division, the USPTO, NIST, and trying to get through the last decade, get past continued uncertainty, my own note I can't read, how to best balance the interests of SEP owners and standard implementers. And we have failed. We have nothing right now that represents United States government position with respect to SEPs and injunctions. So let's go through the sorry history. 2013, policy statement on remedies for SEPs subject to voluntary FRAND commitments. United States Patent and Trademark Office and the Department of Justice's Antitrust Division. These are the two people who put this statement together. It was focused on concern about risk of holdup. And the gist of this statement was you would be precluded from issuing, it was an ITC action, so it's in terms of exclusion orders, but that's an equivalent to an injunction. You were precluded to issue a exclusion order, an injunction, in the circumstances that you would run into in an ITC action. So in plain English, no injunction, okay? You could do whatever you wanted to do vis-a-vis SEPs, but you couldn't get bit by an injunction. Nobody was happy about that, depending upon whether you were an innovator or an implementer. Fast forward, 2019, we get another policy statement. Oh, no involvement of the Federal Trade Commission in the 2013 statement or NIST. We fast forward to 2019. We've got the USPTO again. We've got the Department of Justice Antitrust Division again. Now we've got the National Institute of Standards and Technology. They're involved. First thing they do, they throw out the 2013 statement. All right, so 2013's gone. Now we're talking about 2019. They're all concerned about risk of holdout. So what happens? They change the policy statement around so that all remedies available under national law, including injunctive relief and damages, should be available for SEPs that are subject to FRAND commitment. Rejected any special set of legal rules. You just used the way it worked for everybody. So sea change, right? We go from no injunction, now we've got an injunction. Okay, we've just about to switch who was in the White House, and we're not going to go through that. Now we talk about the draft 2021 statement. Now, the 2019 statement's still in effect. We start working on a draft 2021 statement, and it largely echoes the 2013 statement. Are you getting a headache by now? I mean, your eyes get crossed trying to follow all this. All right, so in any event, right, they go through, essentially they go back to the 2013 statement, and they say, now we're worried about the negative effects of both hold up and hold out. So now we've got everything in the mix. And they more or less go back to a no injunction regime. All right, so 2013, we got injunction, no injunction. 2019, we got injunction. Draft 2021 statement, now we're talking about going back to no injunction. You got that now? So we're like sine wave. Withdrawal, June 8th of 2022, somebody wakes up in the morning and goes, I got nothing better to do, so let's withdraw the 2019 policy statement. And not only did they withdraw the 2019 policy statement, they don't reinstate the 2013 policy statement. You got a headache by now? Okay, so what have we got? We have got, I can't say what it is in Italian because if somebody translates it, I'll get in a lot of trouble. Nothing. We got zero right now, okay? And when someone was asked, well, why are you doing all this? The quote was, withdrawal best serves the interests of innovation and competition. The Department of Justice asks for comments back when they were doing the draft 2021 statement, and they get all these nice comments, et cetera, and they still let it go. DOJ is then asked, well, what are you going to do? Because you don't have a policy anymore. And the Department of Justice says, our future enforcement practices clearly have been announced, And the Department of Justice will review conduct of SEP holders or standards implementers on a case-by-case basis to determine if either party is engaging in practices that result in anti-competitive use of market power. Great. Nice. Where are we? We have zero United States government policy on this. Now, those of you in the room have heard of Director Vidal. Well, Director Vidal is the most energetic human being on the planet. I don't think she sleeps. She is very, very heavily involved in this whole SEP issue. And she actually testified in front of Senator Coons. You may understand that. And the implication of what she said, now I'm being careful to say implication. You got to watch what you read about who supposedly said what, because they're not terribly accurate. But the implication of her testimony in front of Senator Coons was, if a new EU regulation should become law, like the one they're looking at right now, DG GROW, the United States will seek to respond with measures of its own. It will not allow the EU to assume the role of the world's SEP FRAND arbiter, right? That's important. Will not allow the EU to assume the role of the world's SEP FRAND arbiter. Now, the Department of Justice Antitrust Division is nowhere to be found anymore. They're still out there, but nobody's paying any attention to them. So 2 weeks ago, the director throws a party, essentially, where they set out 4 hours. They invite 3 of the important entities. They invite the USPTO, NIST, and for the first time, the USITC. Why is that important? Because ITC exclusion orders are the closest thing that you can get to an injunction, and it's all baked into the ITC statute. So they're all there. All kinds of people come in. The innovators come in. The implementers come in. We got testimony up one side and down the other. And here's the quote from her. We have heard some concerns about what is happening in Europe. We have heard some people to be very excited about what is happening in Europe. We have heard concerns about other countries in terms of how they are trying to adopt something similar to what Europe is doing. We want to take a position as the US government. We need to hear from all of you that are involved, so we take a position when we are fully informed. Great. When are you going to do this? At the end of this meeting, NIST leaves with their own 12 questions. Director Vidal urges all the people who are listening to submit written comments to the USPTO. No date. So we're building a big pile of data. I'm not exactly sure what we're going to do with it. But all I can tell you is we are still sitting out there, we being the United States government, with no policy in this area. And we went through like the loop. That's where we are. I'm done.
Well, well done.
I beat it by 3 seconds.
Well done. Well, thank you very much, Ken. I have a couple follow-up questions, but I want to make sure that we have time for audience questions. Anybody have questions? Raise your hand. If you don't, I'm going to call on you. This is a law school here, after all. There's a request for comment from the USPTO and NIST. I think the comments there are due November 6th. There's a separate request for comment on just standards in general from NIST, also due November 6th. The term of this administration ends in about a year. Obviously, if they get renewed, there's more that can be done. But is there any time left for the administration to do anything? And if not, is there any other opportunity here in the United States to get something more definitive, either from the other branches of government, either from Congress or from the courts?
Oh, I have to answer that one?
Yeah.
Oh, okay. I don't know. No, I'm being serious. Okay, the time is, there's enough time available depending upon how you try to do it. Now, I didn't tell you about what IEEE did during this same time period, because I just don't have enough time, but IEEE, now that's not the United States government, that's like the US version of Etsy, they changed their whole structure around, so you can now get injunctions according to the IEEE. So, and that was done fairly quickly. So they can find ways, whoever the they is, to put something in play. Director Vidal can do it essentially like that, right?
Well, sure, the director can do it like that theoretically, but of course, the next director, the next administration cannot do it also just like that. So, you know, if you're watching the European Union, they're promulgating a regulation, as you've referenced, Ken, and, you know, if implemented, that's longer lasting, and to some extent, you know, there doesn't seem to be any mechanism in play in the United States to promulgate similar long-lasting policy position.
She's very definitely watching what's going on in Europe, but the problem with what's going on in Europe is there's no hard timetable on that, as I understand it.
So let's turn to that for a second, but I want to make sure we go to the audience. Yes, sir.
Ken, the word you were looking for was forgotten. But,
Was that in Italian?
That was not in Italian, it was in Yiddish, and I was afraid to get translated, and then I'd really be in deep.
yeah, I understand.
Trouble.
So the only question I have is, do you think it's better to have a policy that changes every 2 to 4 years based on changes in administration, or is it better to have no government policy at all?
That level of uncertainty makes making business decisions, you know, so it's virtually impossible if you know it's going to cycle. If you know that your IEEE or your Etsy component is pretty much staying steady, you can get some comfort from that. But I think my personal view, given my druthers as a trial lawyer, I wouldn't want it changing every year, 18 months. You wouldn't know how to advise somebody what you can do, what you can't do, what's safe from a business standpoint. Are you going to be a willful infringer under our law? It's too complicated. So I'd rather something steady that makes sense.
Maybe if one reaction I have is also that the U.S. policy statements and the EU regulation seem to be a little bit of a different nature. One of the things that has been said about the U.S. policy statements is that it was the government trying to formulate a position on how courts should decide certain cases, whereas the EU regulation, at least on face value, explicitly steers clear from trying to give guidance to courts how to interpret the YYZTE framework. So I think that one of the things that I find appropriate about the statement to say the best course of action is not to have any policy statement is that it's probably appropriate to leave courts make the determination whether an injunction should be granted, which is different from having a policy such as the EU, which is not about the application of substantive law, but it's basically the creation of new legal principles, which obviously is in the legislative realm.
I was sort of involved in the IEEE standards, and it would be nice to get your feedback on their approach. I know it's been a problem for a number of people. They've been having seizures because of the whole darn thing. Could you give me a critique of what do you think IEEE did right and what they did wrong?
Give me 2 seconds to flip to my IEEE.
Well, while he's doing that, let me just kick that off. It's odd because they are announcing different policy and different interpretations of the same standard that's been in existence. So midstream, on an existing standard, they're announcing different ways of reading that and imparting upon that standard different types of obligations and treatments. But
it would take me too long to run you through all of the strange machinations that happened at IEEE. We had the Department of Justice when they made the 2015 rule changes, which restricted injunctions, which is one of the three main things that people complain about at IEEE. The Department of Justice put out a business review letter in February of 2015 that the IEEE policy changes did not threaten business competition. We go forward to 2020, and out of the blue, the Department of Justice issued a supplemental BRL to that earlier BRL saying, oh, everybody has misconstrued as endorsing the IEEE policy that earlier situation. To my knowledge, that's the first time they ever did anything like that. A supplemental BRL to tell everybody how you thought we meant this to be read has been wrong all the time. And while that was going on, right, what DOJ antitrust was doing that, the IEEE was changing the rules. So as of January 1st of this year, they have removed the ban against seeking injunctive relief against unwilling licensees going forward. Now, the gap between 2015 and here still, it didn't get grandfathered back. So if you made commitments or statements like the negative letters back in the day, you can't retract them. You have to live with that. And that's the main thing that I've been told when they made the changes, got people very angry that they didn't figure out a way to take that off. The IEEE thing is a real, I mean, to me, these are trial lawyers' worst memories. If you have to try to explain this to a jury, they look at you and they kind of go, what? Because it's so complicated, you can't figure it out. It doesn't seem to make a whole hell, to me, it doesn't seem to make a whole hell of a lot of sense. But that's where they are right now. People are not happy about the gap, but they're happy about the fact that as of January of this year, IEEE said no restriction on injunctive relief coming from IEEE.
Well, I oppose that.
Okay, well,
But, yeah, I was in the doghouse.
Oh, right here.
So the kind of the regulatory or statement situation in the U.S. is different, as Justus said, from the situation in the EU on a number of levels. And I don't think it's not great just to put out a DOJ policy statement that's based on antitrust law that tells courts what to do. That doesn't have any force of law or anything like that. It doesn't really provide certainty because we saw what courts did with the last ones, which is basically not a lot. At the same time, I'm not so sure it's great in the U.S. to leave FRAND to kind of leave courts to say everything because juries are a thing in the U.S. and FRAND is decided, at least when there's past damages, by a jury. That's Federal Circuit law in the United States. So you're not going to get, even if you start getting decisions in the U.S., more decisions in the U.S., the same type of clarity that you're getting from the European case law that you guys went through earlier. So my question is going to be off the panel and to Director Iancu, which is, so does Director Vidal, who currently has your former job, have any power or ability to promulgate anything that would actually be useful in this area?
I'm glad he asked you first. Go ahead, this ought to be good.
Well, I won't comment on what Director Vidal or any particular director can or should do. The PTO director does have the theoretical ability to promulgate regulations, right, through the notice and comment system. So it is theoretically possible that the PTO or the administration in general, right, PTO in combination with DOJ and whoever, can come up with a framework and a set of a framework for FRAND. The problem, though, is that it's the same issue as you've already outlined. It's not binding on the courts. And these decisions are made on a case-by-case basis in the courts. The administration can put out the guidance as a point of view, and it does have importance, right, at least with respect to what the DOJ will investigate as, an anti-competitive behavior and so on. but it does not really have the impact that and the clarity that it's going to be required from the courts. The only option really is, frankly, either if the Federal Circuit or somebody, or the Supreme Court puts out some clear-cut guidelines that are going to be followed down the road. And we have examples of that in patent law. Take, for example, the Georgia-Pacific factors that were put out decades ago by a district court. Everybody follows that. Everybody's been following that for a very long time. If they make sense, if the approach makes sense, and it becomes respected over time, courts will follow it. So that's one option. Another option would be legislation from Congress. But, I think we all have lives to live and not wait for congressional action.
I think both.
You know how things, just real quick, I appreciate the fact that a lot of people in this room don't like juries, but you're stuck, right? I mean, I realize it doesn't make you happy, but you can't constitutionally, believe me, people have tried, you can't get away from a jury. But how some of this stuff can get into the mainstream is you've got a lot of very good trial judges around the United States, and I would say Chief Judge Gilstrap is one of them, who do it right. They don't have a thumb on the scale. They make their rulings. They write great opinions, and that all gets added to the law. So someone could look at something that Vidal is doing, and they might comment on it. That doesn't mean they're bound by it, but they might say, hey, I considered this, and I didn't do it because, so that's one of the ways this stuff can get worked into the system. I'm sorry, John, I didn't mean to interrupt you.
Yeah, I had something, but also Claudia too, so I'll let her go first.
Sorry.
Oh, okay. Thank you. I think it's risky to do that exercise because when it's a complex topic and there are differences in each case. So we've seen in the EU what happened with the draft regulation. I mean, it's a mess. I don't know how to say this in a diplomatic way. We have more questions than answers with this system. So when you get a very, very complex topic and try to translate it into simple solutions, this usually doesn't lead to good results.
So John gets the last word here because we're completely out of time. We're over time.
Well, I was just going to point out that one unintended consequence, I think, in the policy statement from 2013 when it was first issued was that it has more sway than overseas than it just has in the United States as well. We found that regulators in foreign countries, especially in China, latched onto that policy statement and said, well, look, the United States is saying that injunctions should be available, that this should be a more implementer-friendly regime, and overseas, those regulators have more power to implement policy and make changes than the agencies do here.
There have been a lot of the commentators in this interregnum when Director Vidal was trying to decide, been a lot of comments that are talking about China. It's not like people aren't aware of how they think the Chinese are going to treat all this. Mm-hmm.
So just to leave a parting thought here, and then we'll adjourn. In the end, these are private disputes, and they're private parties negotiating amongst each other. And to Claudia's point, it really is, they're complicated, they're all different, and jurisdictions all over the world. The reality is that the best, in my view, approach would be to trust the private parties to do their own negotiations without the government putting its thumb on the scale. We trust private parties to do their own negotiations in every other area of patent law. It is, this is obviously a complex area of law, but still it doesn't mean that we can't trust private parties. And in the end, as Ronald Reagan said, the most frightening words in the English language are, I am from the government and I'm here to help.
It used to be, I'm from the IRS and I'm here to help.
Right. But the area of law remains complex, and it's great to hear from so many experts on this panel, their thoughts from around the world, and hopefully we'll have more clarity soon enough, at least in the United States. Thank you all very much. Thank you for having us.